approved by the ID, you say she could make recommendations or suggestions that include others. In your experience, has she gone so far as to specify who by name, not just include another 2 investigators or a prosecutor? Have you had that kind of experience?
I've never had such an experience, commissioners, but she will suggest, maybe looking at the balance of the team, that you still need another prosecutor, either a junior or a senior, without specifying a name, without recommending, include so-and-so. She'll just advise, beef up your team, you still need another data analyst or this or that, but without specifying a name.
Okay. And again, your experience, have you had experience where the ID picks the team for you? Have you had that kind of experience where she specifies these people that she has already spoken to, and you're married to them, so to speak?
I've never had such an experience, commissioners. It has never happened.
Thank you.
Yes.
Yes.
That is Annexure 7.1. Okay. I wrote this paper then on the 16th of September. I then emailed it to, as per page 1 of the badge. You see, I then emailed it to the admin personnel, Sinyani Manchidi, with the subject recusal from the matter of State versus General Khumalo and others. Attachments, it appears I wrote that email on top of I wrote the memo on top of another document. That is why the attachment appears with the subject Estina request to NDPP. So I worked on top of another memo. On page 1, the memo is directed to Advocate Johnson, Investigating Director, and to Mr. Sissoko, Head of Operations and Investigations, from Advocate P. SERUNYE, Deputy Director of Public Prosecutions. Subject, recusal as prosecutor in the matter of State versus General Khumalo and others. The memo is dated 16 September 2025. Paragraph A, purpose 1. The purpose of this memorandum is to inform the Investigating Director and IDAC Head of Operations and Investigations of my recusal from the aforesaid matter. Background. About 4 weeks ago, the ID formally authorized me to be part of the prosecution team in the matter of State versus General Khumalo and others. The matter was already on the court roll, having been first enrolled on 27 July 2025. And it seems on the email I'm repeating the same mistake of date of 27 July. It actually should read 27 June 2025. In August, the matter was remanded to 8 September 2025 for a formal application in terms of Section 63 of the CPA Act, brought by accused 1, 3, 4, and 7. On 8 September 2025, I presented the state's case, assisted by Advocate Joy Tlatwayo. The application commenced on that day but not finalized. The matter was remanded to 15 September 2025 for continuation. On 15 September 2025, the matter could not proceed due to the fact that the Magistrate Court building was waterlogged and some of the courtrooms did not have electricity. The matter was then postponed in Chief Magistrate's office in chambers. The accused were called into the said office and stood behind us, in bracket us referring to the lawyers, facing towards the magistrate. Accused 4 was standing closest to me. When I turned back to look at the accused, I then noticed, for the first time since the first appearance, that accused 4 is a person, the person that is known to me. Accused 4 and I grew up together in the township in Mabopane. We actually played soccer together for many years, albeit for different teams. For all intents and purposes, accused 4, in brackets, Josias, as we used to call him, and I are homeboys. Between yesterday and this morning, I have verified that accused 4 is the same person I grew up with. Thus, I have formally decided to inform IDAC management and recuse myself from handling any case in which Mr. Josias Lekalakala and his family members, in brackets, and associates are accused persons. I have already disclosed this fact to my fellow IDAC managers in an earlier management meeting held this morning. Conclusion, to avoid any negative perceptions and in the interest of justice, I'm formally recusing myself from this matter and any matter that may involve family members and or associates of Mr. J. Lekalakala. On 29 September 2025, I'm formally going to recuse myself in court before the magistrate since I was still addressing the court when the matter was adjourned on the last occasion. I did not recognize Mr. Lekalakala in court on the 3 previous occasions. Otherwise, I would not have been part of the prosecution team right from the onset. Whilst I was part of the case, I prosecuted it to the best of my ability, and the record of the proceedings will bear testimony to that fact. I just do not want any wrong perceptions to be created by my continued prosecution of somebody that I grew up with. My name and integrity mean a lot to me, so are the interests of justice. This memo, you'll see it was dated 16 and addressed to Mr. Soko and Advocate Johnson. As I indicated, Commissioners, I tried to locate the signed copy. I couldn't find it, but it is backed up by the email PS7, where Mr. Soko confirms that the memo was brought to my attention, referring to himself, Mr. Soko, and I have also brought it to the attention of the ID engaged by the magistrate. Neither way the defense, before the magistrate decided on this condition. And for that, that's the first point. But secondly, the magistrate did not give reasons for imposing this condition. And I think those two factors are what swayed the decision in favor of the defense. The High Court saying, when reasons are not given, it's difficult for a party to the presidency to know why a decision was made against them, and there's a constitutional case to that effect. And furthermore, the fact that you are not engaged to address the court on that was also wrong, and that led to the conditions being set aside. On hindsight, yes, we ought not to have opposed it on those bases, but at the time, looking at the Act, it says there's nothing wrong that the magistrate did. He has the powers in terms of 6012 to impose any conditions. Had he given reasons, had he engaged us to address him, that condition would have stood.
Okay. We'll come back to it, Mr. Serunye, and because Ms. Johnson did testify to this, specific questions were asked of her about this, and she had certain answers and explanations. So I would like to hear your views about it, but we'll get to it.
Thanks, Commissioner.
Thanks, Ms. Paul.
Thank you.
Thank you.
Paragraph 42, the accused thereafter abandoned the Section 63 application. That is now, after the magistrate had recused himself, the chief magistrate was trying to arrange another magistrate to take over the 63 application. And the accused then, because of that delay, they then brought a Section 65 bail appeal. Section 65 of the Criminal Procedure Act bail appeal. We again had a discussed with our boss, and we're giving a go ahead to oppose the application. And both matters served before the High Court, and the judgments are attached as PS8. The judgment for the bail appeal and the order for the recusal is PS9. In the bail appeal, PS8, the High Court agreed that the presiding magistrate's decision to impose the decision without engaging the parties and giving reasons was wrong in law and therefore ought to be set aside. On PS9, in relation to the recusal of the magistrate, the High Court ordered in our favor to say yes, the magistrate ought not to have recused himself for those reasons given, not engaging you, and the reason given is also not in line with your rugby union matter. The bail appeal succeeded.
Just before you proceed with the next paragraph, in practical terms, you would have had a conversation about the bail amendment application, the 63. Did you have a similar consultation with the ID regarding now the bail appeal, and did she give positive permission or consent for you to proceed with appealing? Opposing the appeal.
We did, commissioners, and we informed the ID, and then she gave us permission to go ahead with the opposition on the Section 65.
And when you do that, does she have sight of any of the affidavits that are filed, particularly in opposition?
She does, commissioners, and I must say everything that we were doing, we were sending to the ID. The Section 63 bail amendment application, all the affidavits of the accused were sent to the ID, and our responding affidavit of Mr. Brian Padayachee was sent to the ID, and the defense then asked for a postponement in that Section 63 bail amendment application. They then, on the next date, submitted an affidavit by General Masemola in support of the application, indicating that he had lifted their relocation to other offices. And that affidavit as well was given to the ID. I remember sending an email to the ID asking her that we want to, after receiving this affidavit of General Masemola, we want to respond. Now, how do we do it? Do we subpoena information from General Masemola, or do we serve them with a 28? My question to her was, do we do it by way of a 28 or by way of a letter under your signature being the ID? And she sends me an email to say, serve a 28, which is what we did. And we got further information, which then allowed us to prepare additional affidavits of two other officials, which affidavits we then also handed in support of our opposition. So she was kept abreast at all times of what was happening.
And do you recall whether Mr. Padayachee's affidavit in opposition dealt with that specific bail condition related to whether or not you sought that condition to begin with?
What's the question again?
Do you recall whether Mr. Padayachee's affidavit in opposition set out that or indicated that this bail condition was never sought or anything related to that?
You mean the affidavit which was filed
in opposition?
In opposition
of the bail appeal.
I cannot recall, but if I check on my emails, maybe those can jaggle my mind.
All right, thank you.
Yes.
You can proceed to paragraph 43.
Yes, the bail appeal succeeded while I contended that the magistrate was in law entitled to impose the condition. Okay, while I contended that the magistrate was in law entitled to impose the condition, I was constrained to concede that he had failed to give any reasons for imposing the crime intelligence entry condition, and it was on that basis, that is the failure to furnish reasons, that the condition was set aside as irregular. The review of the magistrate recusal also succeeded, the court holding that the reasons he had given for recusing himself were not in accordance with established principles. At 44, having completed the Section 65 bail appeal and the review, I had no further involvement in the matter. Paragraph reading my concerns regarding the Mokwele matter. Once I was officially involved in the Mokwele matter, Advocate Tlhashwayo and Ramsemi came to me to voice their concerns about the lack of evidence in the Mokwele matter. This is as way back now as 8 August when I became involved. Since there had been no DDPP on the matter before my involvement, I could understand why they felt that they could not address these issues directly with Advocate Johnson due to the power dynamic. Having read the docket on 16 August 2025, I was not satisfied that the corruption charge was sustainable on the available evidence and current formulation of the charge sheet. And as I said, and I said so in writing at the time, my concerns were not the product of hindsight. I recorded them contemporaneously. At the time, 16 August, that Saturday, I produced those queries and I raised a number of questions. I remember one of my questions to them is why were these generals arrested? I couldn't understand. Why are they charged with corruption?
Before we deal with your specific concerns, just one aspect here where you say that since there had been no DDPP on this matter before my involvement, I could understand why they felt they could not address these issues directly with Advocate Johnson due to power dynamics. What do you mean by power dynamics?
Yeah. Look, the two colleagues are juniors. And it's not have been easy for them to go straight to the ID to raise issues. I'm talking about issues that they were raising with me. They had a lot of complaints that the investigators were not listening to them. They were not carrying out the instructions that as they were delivering to them. It appeared to me, in fact, the relationship was not that good between the investigators, especially Brian Padayachee and Advocate Ramsemi. They were not in speaking terms when I came into the team. So I tried to put them together. In some of my emails, I'm saying to them, look, we're playing for the same team. Let's have meetings. Let's talk. Let's iron out whatever problems that we're having. So they couldn't. The two juniors couldn't approach Advocate Johnson, and that is why maybe they felt at ease to come to me and make all those complaints, relate them to me. Not that it was easy for me as well to approach Advocate Johnson. I respect her a lot. I've known her for many years, and I view her as my senior, and therefore I couldn't just barge into her office and say, but what's happening here? Why did you arrest these people? Why this? Why that? Is why I put it in an email. I raised all my queries in an email, and I forwarded it to my colleagues. Then I forwarded to her via her PA, and it was not only this one email. You'll see, I think I sent about 2 or 3 where I was saying there's a problem with this case. The way it was investigated, it was rushed. I remember I sent an email directly to her, and I said, it appears this case was rushed. If anything, there might be a case of fraud or there, but the way the investigations were done were just not on with me.
Just before you continue to your specific concerns, when you say that it was difficult to approach Advocate Johnson, was it purely because of her seniority, or was there something in her management style that made it difficult to approach her?
Yeah. Look, I don't want to sound otherwise now, but yes, management style as well as in, she could be unpredictable at times, you know, and you know, she's a very good manager, make no mistake. For as long as she was in the IDAC, that organization, and even now, I mean, we headless as it is for the last week. She resigned last week, Monday. But the organization is continues running itself. It's like a steam train which is on the track. It's all because of the good work that she's put in. You know, the discipline is there amongst the colleagues. So she's done so much work that even when we're not having an acting head or permanent head, the organization can continue to run itself with the help of, obviously, the CEO, Mr. Sissoko, and the 3 deputies that are there. So I think it was more because of fear that how is she going to react, you know, when we take these issues to her, which was also the same, I mean, for me, at the level of DDPP. Not that I couldn't raise issues with her, but you don't know how it's going to end. I referred earlier to a meeting where she was angry with me for raising the issue of a Section 27. So she told me straight in front of the 2 juniors, why are you making an issue about this? go and work? Why? I've seen the document. Why do you keep on questioning or second guessing your investigators? So that is what I refer to.
So in a sense that she, on the one hand, like you said, she's a good manager, but on the other, if you were raising concerns and questioning her decisions, she didn't take kindly.
She didn't take kindly to that, and yes, and she'll tell you straight.
So were there many?
I must say, Commissioner, that it came as a surprise to both me and Advocate Mshololo, who were defending on the day, that before we started, the magistrate just said, I want to address the two of you. I've been subpoenaed by the commission, and as a result, he was recusing himself. He did not give us an opportunity to address him on what he was anticipating to do, and that's one of the reasons why we then took up his decision on review to say, in line with decided cases, at least you ought to have had us engage us, but in any event, the reasons that he was giving were falling short of the established principles, and that is why we took the matter up on review.
But that same consideration that he didn't give you the opportunity to address him when he decided to recuse himself, why was that not your consideration on the bail issue? Because in the bail issue, he didn't give the accused, we later learned in the appeal, that the accused were not given the opportunity to address him on that condition. I'm not probing at this stage, it's because you've touched on it, but it is a subject of interest that I would like to hear you on, not necessarily now in full.
Yes.
But it's something that I would like to engage you on.
I understand that. Can I quickly just take out a copy of my book here just to make... Commissioner Baloyi, when the reason for that was, and we looked at the provisions of Section 60 of the Criminal Procedure Act. Especially at 60 subsection 12, if I'm not mistaken, I want to go there. Section 60, subsection 12, the court may make the release of an accused on bail subject to conditions which, in the court's opinion, are in the interest of justice. And section 60 says the magistrate must weigh up the facts presented before him and the evidence before him, and at the time, even though neither of the parties had addressed him on this specific issue or condition, but our understanding was that he has the powers in terms of Section 60, subsection 12, to impose any conditions which, in his opinion, were in the interest of justice, allowing him to release the accused on bail. We objected to the appeal on those grounds. But when one reads the record of the matter at the High Court on appeal, and the presiding judge took me on that, and I had to concede, commissioners, that yes, much as I didn't know much about the case on the day of the bail application, I was seated there, but I remember that my fellow prosecutor note, I raised, among others, the following questions to the team. But all these are covered in my email. 46.1.
Perhaps as opposed to reading the summary, we can go to the actual annexure. If we can go to PS3.
Okay.
You'll see it starts with the email that you sent to Ms. Sekukuni, who is the PA to the ID, where you brought this memo to her attention. And then below that would have been the email you sent to the team members, wherein you gave them Saturday homework while you went and watched a nice game, I see. And then the next page, on page 25, would be where you deal with your concerns. Can we go there?
Yes, Council, you'll see, I agree. You'll see at page 24, it's my email. Actually, the first email will be the last one.
Yes.
You'll see I sent it at 2:51 on the Saturday to the team members, Advocate Tlajwayo, Advocate Ramsemi, Mr. Brian Padayachee, Chief Investigator Daylan Perumal, Investigator Charles Eels, Investigator Patrick Mlambo, and I also copied the project manager, Mr. Sepotale. I reference the subject as trial preparation, Note 1. Colleagues, here is your Saturday homework. I'm knocking off now to watch Pirates and Sundowns. PS. It was 2:51. I've been in the office since in the morning.
Can I just ask a question? What's the difference between a project owner and a project manager? Because we've encountered Mr. Tlale's name before as a project manager.
Yes. The difference, Commissioner Baloyi, is that Mr. Tlale is one of the 4 project managers that we have. They are involved right from the beginning of the case. They prepare our monthly reports. They are also a link between us and HR in terms of where we need resources, and they also prepare some documents, some 28s when I prepare a memo or an application, and once it's settled, they are the ones that forward same to the office of the ID, and when we receive a report back, they do a lot of work in the team. They help with the preparing for the budget of the team. When we're traveling, they are the ones who prepare memos for traveling, and when we need resources like computers and memory sticks, so they manage the whole project in that sense.
So we're in I think we've encountered Mr. Tlale and we've had a discussion about him where his name appears in a summons, and it says inquiries.
Yes.
My direct question to you is, does he make the decision, I want a summons, and then he prepares the application, or his is an administrative function?
No, it's more of an administrative function.
Okay.
Commissioner, he doesn't make that decision. Lies solely with the DDPP on what type of investigation do we go after consulting the team.
Yes.
Whether we go at 2813 or 2818. Project managers do not make those decisions. Yes.
Thank you.
I'm copying him because he must know what we're busy with, what we're doing. He keeps the file of this matter. So that is why I wanted him also to know that investigations are still outstanding in this matter. And when we're doing a case plan, he must file those. Everything that we do, the project manager must know. So I sent them this email, and the email had an attachment containing queries. And later, the very same day at 3:58, I forwarded it to Ms. Innocent Sikukuni. You'll see the message to Ms. Sikukuni has an attachment document 1.docs. The email, the document, that is my document, is now on page 25 with the heading, Dear Team, 1. I have just finished reading the first docket, Brooklyn Cars, in bracket, General Kumalo and others. 2. Starting from Monday, I want to sit with the prosecutors, Drew and Joy, to start working on refining the charge sheet, to have it ready for the bail condition amendment application on 22 August and for disclosure. 3. As part of our preparation for the case, the response to the application for further particulars, in bracket, which I'm sure we are going to be served with in due course, and preparation for the trial, I want to know the following, in brackets, the questions are directed to all the team members, I was saying. 3.1, why were the accused charged with corruption? 3.2, who corrupted whom? 3, do we have evidence in the docket to prove allegations of corruption against any of the accused? If so, what evidence is that? 3.4, do we agree that in terms of PRECA, the Corruption Act, the giving and or accepting of a gratification should be for a certain aim or objective. PRECA uses the word, in inverted commas, in order to act personally or by influencing another person so to act in a manner described in Roman figures 1 to 4. 5. That means a person gives another a gratification and the other one accepts or receives in order to act in an unlawful manner, as out in Roman figure 1 to 4. 3.6. Now, following paragraphs 3.4 and 3.5 above, why did these generals in the SAPS go out of their way, rig the appointment process, risk their jobs, and flout the National Instruction 11 of 2017 to appoint a 29-year-old inexperienced civilian to the rank of brigadier in crime intelligence? I'm asking the question. Who is this young lady, in bracket Mokwele, for whom 6 generals in the SAPS are risking losing their jobs for? What did the generals stand to gain or expect to gain, in bracket quid pro quo, by giving her gratification, which is the position or the job? What did they stand to gain? I don't have that evidence in the docket. 3.8. What are we saying? Are we saying the generals gave Mokwele a position stroke a job in crime intelligence in order for Mokwele to do the following? To do what? I'm asking them. What did Mokwele have to do in terms of Roman figure 1 to 4 of PRECA? 3.10. Did she give or promise to give any quid pro quo to the generals? In law, she does not have to. But there must at least be an understanding between Mokwele and the generals that the job is given to her for a particular unlawful reason, in brackets, in order for her to act unlawfully as set out in Roman figure 1 to 4. She was just a young lady occupying an ordinary position at BMW at the time. I cannot see that there was anything she could offer to these generals, in brackets, except giving them cash as a thank you, or if she was having a relationship with one of the male panel members, stroke generals. I'm trying to find out why are they giving him a job which, according to the state, she was not deserving to get. And what did she do in return, or what was expected from her? 12. Did the team subpoena the bank accounts of the generals and Mokwele to ascertain if she did not make any payments to them for giving her a job? If not, why not? 3.13. Were the cell phone records of the generals and Mokwele obtained and analyzed for any communication relating to the application for the post, preparation for interviews, or discussions about payments? If not, why not? 3.14. Were computers that were used by the generals during the period in question seized and or mirror imaged to look for communication between them and Mokwele, or, in brackets, or anyone related or associated with Mokwele, prior to or during and after the interview process? If not, why was this not done? 3.15. Did the team investigate any possible family relations between Mokwele and any of the generals that formed part of the panel? Paragraph 4. Colleagues, the appointment of this young lady to such a position does not make sense and is suspicious, but suspicion alone is not enough. There is a reason why she had to be appointed, and that reason is our answer. It is the quid pro quo. We must look for it, I'm saying. Paragraph 5. Otherwise, we remain with fraud regarding the flaunting of processes to appoint her. Yes, her shortlisting and eventual appointment was fraudulent because she was inexperienced, in brackets, which was one of the requirements for the position. Many other applicants were disqualified for lack of managerial experience. How did she make it to the top 5 and eventually top 3? 6. She also made misrepresentations in her CV, in brackets, I'm saying fraud. The investigator should follow up the validity of the project management certificate at Stellenbosch University. 7. She also claims to have been top of her class in her first year studies for MBA. She does not say where she was registered for the MBA, and whether she eventually completed it. I must say later, with the investigation, it became clear that she had finished the MBA. So that information was secured after I've raised all these questions. But when she submitted the application, she only completed it after submitting it, I think a month after, in May 2024, whereas the application was in
let me just correct you there, because in her application on page 265, that very issue you are raising, she did say that she's still busy with the MBA and she will only complete it. If you look at page 66, bottom of the page, it is expected. So at the time of submission, she did not have it, and she said so in her CV. And in fact, in her job application on page 263, the only 3 qualifications she lists as being relevant to her application. In other words, she says, I have this many other qualifications, but they are not necessary for this application, because what the job requirements, what the job description requires is these 3. And then she lists all 3 of them on page 263 of file 2. She says BTech industrial engineering, and then she says the national diploma in mechatronics engineering, mechatronics. So she was saying to subs, for the purposes of my application, you need only look at these 2, because that's what the advert requires. I have these other things, but they are not relevant to the application. So she made that very clear. There should have been no reason to go look for things that she's not relying on for the purposes of the application. They are mentioned only in her CV because she gives a full description of what she's doing and what she's all about.
I agree.
Relying on that qualification to apply for this position.
Yes.
It's a by the way that is mentioned in the CV to say, by the way, I've done these other things, but for the purposes of my application for this position, I am only relying on my BTech and my diploma. That's all.
I agree, Commissioner. It's just that when the markings were done for the interview, one of the and I think it also comes up in the email where I'm saying, but also she was given more scores by the panel for educational qualifications compared to Van Vuren and Bapela. And Saka only confirms her matric diploma and degree in engineering. I'll wait for your input. Seppo arrange a meeting. Indeed, for purposes of the application of this position, those qualifications were not even relevant. But the fact that when the panel members are scoring, they consider the educational qualifications of applicants comparing one to another. We needed to satisfy ourselves that she has those, in case they were taken into consideration when the panel was marking.
Yes, but you can't say then she committed fraud. I mean, if the panel takes additional things into consideration, the applicant can be accused of fraud.
No,
what the applicant has put forward is what is required, and those have been verified.
True, I agree with what the commissioner is saying, and I don't think there was any misrepresentation that was alleged in the charge sheet regarding the project management and the MBA, because as commissioner is saying, indeed, in her application, she says that the MBA is going to be finalized in future. In fact, it was only finalized a month after the application was submitted.
And this thing here in paragraph 6, that she also made misrepresentations in her CV. I mean, that is not correct.
Commissioner Kumal, perhaps because we also tried to get clarity on
probably this is one person that I can shortlist. But BMW says now that information.
I I think what I wanted to do was to show you that in the CV, the misrepresentation that is mentioned in the memo is not in the CV. I know where the problem could be on the issue of whether she has appropriate management experience,
Yes.
but that is a different topic, and maybe we will deal with that later on. For now, continue with the rest of your memo, because I was not probing you, but I just wanted to point out to you that the MBA issue, what she said in the CV is actually correct.
True.
And all the qualifications that she listed in her job application and her CV have actually been verified. And you've confirmed that.
I do.
Yes.
I do.
So
Yes.
where there might have been a question mark is on whether she has appropriate management experience. But that's an issue for interpretation, because it's a term that is defined in another document, and even the way it is defined is a bit vague. But the CV as it stands, the qualifications are there, and there's no issue with them.
I agree. With regard to the qualifications, I agree. And I, like I said, those were verified, Commissioner.
Qualifications amounting to fraud in her CV.
Right. I'm calling it fraud, Commissioners, because she says in her CV, I've been a middle manager in BMW since, I think she says 2016 or 2017, from the year she started working. And we obtained affidavits, or at least at the time when I read the documents, there were affidavits from BMW, from human resource official, and from a person to whom Mokwele was reporting. Both of them say Mokwele was never a manager in BMW. She was not a supervisor in BMW, and therefore, for her to claim in the application that she was a middle manager amounted to a misrepresentation.
Okay, Serunye,
Yes, Commissioner.
what you say in paragraph 6 and what you are being asked are two different things. You say in paragraph 6, she also made misrepresentations in her CV, in brackets fraud. The investigator should follow up on the validity of the project management certificate. But you confirm that that was done. So that's not the issue. And then the CV itself is on file 2, page 265. I have been through this CV. And what you are saying is simply not in this CV. Unless you can point to me
Get me the thing.
where that misrepresentation, which amounts to fraud, is set out there. File 2 on page 265. And it's a short CV, it's only 3 pages, so it's not very long.
Commissioner, I'm looking at the CV, and maybe in relation to where she says middle manager, it's not coming out of the CV, but out of the application itself. But what she says on the CV, which is a misrepresentation, is on page 267, on the last page of the CV, under accomplishment, where she says that she saved over 1 million in IT security project cost by training and equipping the internal maintenance team to carry out some of the project work.
Advocate Serunye, let's agree that 267, where you are reading, it deals with successes achieved in the current role. because she says, I successfully implemented first robotic process. I saved the company 1 million in IT security. I saved 500,000 in annual maintenance. I reduced the electronic tools management.
Yeah.
That's all she says. And in fact, the affidavit from the BMW manager says, well, I can't confirm these things because maybe other people can. That's what he says. But looking at the CV as it stands, you can't say this is misrepresentation, this is fraud. I think for now, let's just accept that unless you can show that what is stated there, those are not accomplishments and that is false, there is no fraud there. Okay, because this is engagement between you and your colleagues. It wasn't you forming a conclusion one way or the other. You were simply saying to them, let's cover all the tracks. Let's make sure we've investigated this, we've investigated that. And I think all your questions, to be honest, are fair questions to ask if you are given a docket for the first time and you look at it. And then you say something very important somewhere in your statement, because you say even the arrest warrant should not have been issued on these facts.
True. Indeed, Commissioners, on these facts, there was no case. It couldn't have been. And maybe on the issue of the warrant, Commissioner Kumalo, when I first read the docket, because the statement applying for the warrant forms part of the docket, I remember having a discussion with Advocate Lachwa and asking her how did the magistrate authorize this? And I remember she told me on the first occasion when Brian Padayachee went to court to ask for a warrant, the magistrate Tanty Marie said a statement.
So the one that was issued was the second one?
It was the second one to try.
There was one where the magistrate refused to grant the warrant.
There's one where, there must be one where the magistrate refused to issue a warrant because the magistrate was not convinced that there was a case. The magistrate who sees and does this, this. So the magistrate sent him back, and he went and compiled another one, went back, succeeded with the second one. But still, when I looked at the second one,
But why do you say it looks more like heads of argument than an affidavit?
It's because when I read it, it's like a person is trying to, it's like an argument. He's trying to justify why we want to have a warrant issued. But if
Chair said it has more conclusions than facts. That's how Chair put it.
Which I agree with, Commissioners. If you have a case, you have a case. You're not going to struggle with drafting an affidavit to apply for a warrant. And as a prosecutor, you're not going to struggle to draft a charge sheet. If you have a case, you have a case. And I always say to the juniors that come in as part of training, I say, you will see, when you struggle to draft your charge sheet, you must know that there's something wrong with your evidence. If a person stole an item at OK on the 4th of August 2026, your charge sheet reads theft on such and such a day at or near OK Central. This person stole this item. You even describe it worth so much. But if you're struggling to put it into words, what did the person steal? Where? When? Then it tells you have a problem, which is what I was encountering as I was writing this email. Who corrupted who? How? There was no evidence to support all that.
Question, but maybe before I ask you my question, let me say in tongue-in-cheek that if you called those two BMW witnesses, I would have asked, is this an IDAC matter after all? I say that tongue-in-cheek. My question is, your memo seems to me at least, to cover or to raise questions that I would expect a prosecutor to ask before there is an arrest before there is charging and people are made to appear in court. You seem to be asking basic questions. Am I correct in that observation?
You are 100% correct, Commissioner Baloyi. These questions, the team ought to have asked themselves these questions. When I come in 2 months after the arrest, I was not supposed to be asking these questions, especially if a person is charged with, that's what I'm saying, why did you charge them with corruption? Because I'm looking for the evidence of corruption in the 4 volumes in the docket. I can't find any evidence of corruption. The questions that I'm asking, the team ought to have asked itself before making a decision that we are now ready, we're going to arrest. They should have asked themselves, are we going to be able to prove the gratification? Are we going to be able to prove that Ms. Mokwele received the gratification and the intention element which the authors, Steyman and them, say, in order to denote the intention element. That is why I keep on asking, in order to do what? She does not have to do anything to say, oh yeah, no, she gave them 500 rand or this or that, but the understanding between the parties that we're giving you this, we are corrupting you basically, and she's receiving on that understanding. These are questions that the team should have asked themselves. And the commissioners will see as we go on in one of my other memos, even if that had happened, I'm raising another question later, but your charge sheet is defective in a sense that you're charging them with section 4 of PRECA, which says, for subsection 1, paragraph A, a person, a public officer who is, so it talks to a public officer who is given a gratification and who accepts or receives or promises or agrees to accept a gratification from paragraph B, a person from another person. Therefore, the reading of PRECA will tell you that the way they drafted their charge sheet, it was vice versa. They are saying the generals gave to a civilian, the generals being public officials. If one were to stick to the language of section 4, it ought to have been the other way around. The civilian should have been the one who was giving gratification to the generals, not the other way around, because the generals are referred to in 4.1a. They should receive, not give, and this civilian should give, not receive. But in their charge sheet, they were having it the other way around. So these are issues that ought to have been looked at, and maybe the charge sheet also interrogated. But in relation to this is about evidence. Do you have enough evidence to go through your intended charge of corruption? My view at the time, Commissioner Baloyi, was that no. They should have been asked right from the beginning. But then you arrest. After arrest, it's only when you start investigating. Now, somebody can say, okay, what if SERUNYE did not come on 8 August? I wouldn't have asked these questions. Were you going to go on with that evidence that you had at the time? Was that sufficient? Would you have convinced the court that you have a prima facie case of corruption?
Colonel Padayachee thought so, that there was enough to persuade a court that she would have committed a crime in the future, therefore she's guilty of an offense, an unknown crime. So someone in your office thought that there was a good case here, including of state capture.
Yeah. No, I don't agree with that. Definitely, it shows, if you read this as an independent person who comes after the fact, it tells you immediately there was a lot of investigation still outstanding, and you couldn't have arrested, go through the processes, bail application stuff, and only do the investigations after. Especially commissioners that we're dealing with a high-profile case, or at least a case that involves the high-ranking officials in government. You don't just arrest people, put them into the court system, only to postpone for investigations. And these cases, we prepare them over a period of time. It's like in the lower courts where we receive decision dockets. I must prepare it in such a way that there's at least a prima facie case. When I put it on the court roll, the one thing that I must do is to postpone to seek a trial date. If the defense says give us copies of the docket, to postpone for disclosure, but not to put a case on the court roll, which we have worked on. This case, I understand, started in December or November of 2024. And by June of 2025, they put it on the roll. For that 6 months, these issues ought to have been covered. You don't put it on the roll only to postpone it for investigation.
Is it fair to say that your memorandum, the questions that you're raising, suggest that your view at this point was that you don't even have a prima facie case yet at this point?
Clearly, there isn't a prima facie case. When I asked them, for the first question, why are the accused charged with corruption? Who corrupted who? I can't see it. There's no corruption. Who corrupted who? Yeah. So there's no prima facie case, not even on the lowest standard of corruption. There isn't.
And did the ID engage you about this memorandum where you're saying we don't even seem to have a prima facie case? Did she come back to you and tell you, no, you're wrong, we do, and these are the reasons?
But now, Commissioner, I was never engaged by the ID on this memo. At least the investigating officers tried to respond to some of my questions.
Yes.
But what they did basically was just to recite what the Act says, and not to deal with the questions.
Thank you.
You may not necessarily have details, but I'm interested to know whether your questions, I know there was a response, but whether the substance of the issues that you were raising, to your knowledge as we sit here now, was the substance of your questions ever answered cogently?
Chair, they were not. And maybe that is why I wrote a second, or at least in the third trial preparation note. They were not. And I was saying to the evidence leaders as we were preparing this affidavit, and I said, well, I recused myself at least a month and a half after getting in, but if I had gone on and those questions were not answered, I would have withdrawn this case. I would not have prosecuted this case on the basis of the evidence available at the time, unless if all of these questions were answered. I would not have proved the case in any event, even if I went on trial, at least with the available evidence. So I asked questions and I made a follow-up, and I think I sent a third trial note where I got the response was confirmation of Ms. Mokwele's qualifications and one or two other things, but by and large, my questions remained unanswered.
Yes, I'll make a comment that I've made repeatedly during the testimony of the IDAC witnesses. We are not asking these questions so as to pronounce on whether the generals or the officers are guilty or not. But we are asking questions that may touch on whether there was a case at all, because for us at issue is whether charging the generals at all was improper. So questions of whether there was a case to start off with may be relevant to that question, which is relevant to what we are about. Now, I thought I should just again, for those who may be asking themselves, but are they a court that's going to answer the question of guilt or not? So I thought I should just again repeat that comment. It's probably for the third time that I'm making that comment. Let me ask another question. When you sent your email with your several queries on the 16th of August 2025, just before you went to watch Pirates and Sundowns, you also copied the Advocate Johnson's PA or you sent her separately. You sent her separately, and your cover email to which you attach the queries, you say FYI, which means for your information. Here's what I want to understand. On internal IDAC processes, what would your intention have been? Would this have been for the information of the PA only, Ms. Sekhukhune? Or did you believe that she would not hog this, but that she would forward it to her boss, Advocate Johnson? And if your response is the latter, why did you not say this is for the information of Advocate Johnson? Then that way there would be no question that this would end at Advocate Johnson's desk.
Yeah, thanks, Chair. Chair, that is how we communicate with the ID. She's receiving, I would want to believe, numerous emails on a daily basis, and therefore the practice then is we send to her PA, who then sends emails to her. But if there's something urgent, she has said that to me on a number of occasions. It was on a private matter when I was off sick, and then I sent the email to Sekhukhune. They said, no, Peter, when it's that urgent in the morning and you're not feeling well, please send it directly to me. You can copy Ino, but also send it to me. So if it's urgent, then you even call her. Say, ID, I've sent you an email, please check. But when I send it to Ms. Sekhukhune, I'm sending it to her to forward it to the ID. That was the practice, or that is the practice in the office. And I'm sure that she gave her this email. I did not receive any response from the ID on this one, but on the other emails where I did something similar, the ID would have responded to me to show that Ms. Sekhukhune forwarded to her.
All right. That was going to be my next question as to what your
the role of the prosecutor, and you can clarify for me which prosecutor, because there's a junior, you've got a senior, you've got you, the DD, yes. But then there's also the prosecutor at the NPA. As we've understood, they get to approve something. When it comes to the warrant, applying for a warrant of arrest, what are the approvals level? Who finally says something that enables, let's say, a Colonel Padayachee to go to a magistrate and eventually get their J50?
Commissioner Baloyi, what happens is when the team that's working on a case comes to a point where they are of the view that they are ready to enroll, they make a presentation to the ID, and with the CEO, head of operations, Mr. Soko, sitting in. So it is at that level where decisions are taken to apply for a warrant. I must be honest, I don't expect, and I've never seen the ID reading to a point of reading the IO statement. I don't expect her to do that. But in these memorandums that are sent to her, prosecutors would have summarized the evidence in the docket. This is 820. It is the affidavit of Brian Padayachee, which says the following in brief. Therefore, but in the actual engagements with the ID, they must say to her, we are ready. These are the charges that we want to proceed on. Our application for a warrant is ready. Here it is, ID. Our bail statement is ready in case you're going to oppose bail or not, but we've drafted that. And those decisions are then taken. Go ahead or no. I'm of the view that you still have to do 1, 2, 3.
So it's the internal, the IDAC internal prosecutors that look at this application and the affidavits before Mr. Padayachee takes it to court. Takes it to a magistrate who approves the J50. What I'm trying to understand, and it's been a question of concern, at least for me, but where were the lawyers? Maybe Colonel Padayachee can be excused because he's an investigator, but there must be some meaning to prosecution-led investigations, and so you say to us, Colonel Padayachee went to the magistrate the first time and he was turned back, right? Then the question is, well, does it mean the lawyers in there, the prosecutors, had never looked at his work before he went to the magistrate? So I asked the question to try and understand how it works, because it is an important question. What is the role of the prosecutors in what turned out to be a big mess in process?
Indeed, Commissioner Baloy, the prosecutors are there to do exactly that, to advise on legal issues, to read these affidavits. The affidavit would have been drafted by the investigating officer. But before he goes to the court to ask for a warrant to be issued, internally, the team looks into the affidavit. Each member of that team has a copy of the docket. They read the docket, they discuss these things. And the prosecutors are there exactly for that purpose, to advise on those issues. And the other thing is, once they agree that you are going to arrest, then the investigator officer Padayachee would have drafted a warrant, a J50 warrant. That warrant is first authorized by the internal prosecutor to.
In this case, the internal prosecutor, you were not there at the time. In this case, the internal prosecutors would have been either or both Ms. Tlachuayo and Ms. Ramsamy.
And Ms. Ramsamy.
Yes.
One of them would have then authorized that warrant. And for one to authorize the warrant, you therefore have to read first this affidavit.
Yes.
And to say, yes, we have a case, I agree with this. And the warrant also states the charges, I agree with the charges. Then the prosecutor authorizes that. Then the IO, Mr. Padayachee, takes his affidavit and the warrant, the J50, he goes to the magistrate to ask for a warrant to be issued. Okay. There's always a magistrate who's on standby, who's dealing with these issues. The magistrate will also do the same, go through the statement. If there's a charge sheet attached, go through the charge sheet. And if he's convinced that there's a prima facie case, and then issue a warrant.
Thank you.